Okay, it's 9:30, our appointed hour. We're here on the hearing on the request for review of disciplinary action taken against Mr. Harry Allen Spence of the Knoxville Fire Department. And anything we need to deal with prior to beginning the hearing, other than the discussion about one of the witnesses?
I don't think we have anything other than discussion about those witnesses. So.
Okay. There are, Mr. Isaacs, you've subpoenaed at least several witnesses or requested they appear. Erica Frazier is a firefighter who has three-year-old daughters. This is her day off.
Three-year-old.
Three 4-year-old daughters.
Well, that's even worse.
I was going to suggest to parties that we might at least take her out of order so that she and the girls could be excused and could go about whatever they would go about during the day.
What I was had planned on doing was seeing how Chief Sharp's testimony went, and it may be that we don't need all 4 of those witnesses, maybe just one. So I'll accommodate her obviously in any way I can.
And that raises the city's objection to these ladies being called to testify. We made it clear in our brief that their email was not considered as part of this disciplinary action. It came in mid-process. It was not considered at all. Chief Sharp will testify to that. That's what we advised Mr. Isaacs in discovery. So we believe the testimony is irrelevant based on what you're going to hear today.
Their testimony is
Wholly irrelevant.
irrelevant. Okay.
Irrelevant.
All right. Well, what did you say, Mr. Isaacs?
Well, I respectfully beg to differ. One, I don't think relevance is a reason to prohibit us from calling witnesses. I think you could object to the testimony. But there is, for example, one email that is very detailed, that where the chief was given information and provided information that made allegations that were false, that Mr. Smith was a danger to other female employees, other male employees. This person had knowledge of all of the proceedings in criminal court, and I think it clearly goes to just cause and what the chief's mindset was. And there was a communication between at least one of these individuals and the chief. So,
Well, is that Erica Frazier?
it is not Erica Frazier. That would be Miss. I want to make sure I pronounce her name correctly. Miss Plante.
Okay. Well, the question that I raised before we really get started is, do you need to call Erica Frazier, since she's the one with 3 young children? And if you do, that's fine.
I think.
And we can. Yeah.
I think Miss Frazier can be released.
All right. Then if whoever can release Miss Frazier, and then we'll.
Mr. Rich, there are a number of witnesses out there. Do you want them to come in and be sworn in and then get their contact information and we call them? I think Chief Sharp will be the first witness of the day and take a considerable amount of time. I hate for them to sit out there for 2 or 3 hours.
Well, the city has the burden of proof, and the city gets to start. But it's your call as to whether or not you wish to have those witnesses appear. Of course, Mr. Isaac says that it depends on his examination of Chief sharp as to whether he will need any or all of them.
Do you have any objection to us getting their contact information and we call them maybe half an hour before we think they're needed? I know my next two witnesses are 15, can be 15 minutes, call and be here in 15 minutes.
I mean, whatever the court would prefer. I mean, hearing examiner.
Well, we can bring them all in and get everybody sworn. And then we'll see where we go.
Sorry, Franklin. Hearing officer's gonna swear everybody in.
Okay.
Eric and y'all can release the other not. So you can go home, guys, all right? Thank you so much. Everybody else. Is that everybody? No, Erica got released. So she'll go.
Actors been released. Everybody that's going to testify in this, raise your right hand and be sworn. Do you and each of you swear or affirm that the testimony that you give in this matter will be the truth, the whole truth, and nothing but the truth? Yes. Let the record reflect that all witnesses answered in the affirmative.
So if everybody could give Amy your contact information, Mr. Isaac's witnesses, he's indicated he may want you to stand by, but my witnesses can go back to the office and we'll call you.
I'm well with that system for everybody. I mean, there's no sense in,
If you can be back within 15 minutes, we'll start, once we're done with the city side, we'll let everybody know so that you have a heads up in plenty of time. Okay.
Ms. Zara, call the first witness.
Do you want any opening statement at all?
I've read the brief or memorandum of law that both have submitted. I think excuse me, I understand the positions of each side. I would say that it appears that the issues that both sides say, or the issue that both sides say is the issue, is whether there's just cause for termination. And with respect to Mr. Spence, the additional issue of whether the discipline taken was appropriate. So first, just cause. Secondly, whether the ultimate decision of the chief was appropriate, or the issues in this matter. So with that being said, ready to proceed? Let's proceed.
My first witness is Chief Sharp. Would you please state the full name for the record?
Stanley Kent Sharp.
What's your position with the Knoxville Fire Department?
I'm the chief of the department.
And as chief of the department, what are some of your responsibilities?
I oversee the entire department, all the divisions, the 320 plus firefighters.
In addition to overseeing them, what does that include? Personnel issues? Does that include the budget? What are those?
Yes, I oversee all personnel issues, operations, oversee a $50 million plus budget. Also oversee discipline.
With regard to taking disciplinary action, when you say you're in charge of that, is that because you want to be, or is that because you have to be?
That's because I have to be. The city charter and the city admin rules require the department head to administer discipline.
You mentioned the charter. I'm going to show you copies of some documents now. Most of these documents have already been provided to all of the sides in our pre-hearing brief, but I've got extra copies. Article 10 of the charter talks about the director being responsible for discipline. Is that true?
Yes.
And section 1007 in particular, 1007A discusses when you are entitled to terminate an employee. What does that 1007A state?
It says that the director or department head shall only discharge, suspend, demote, or otherwise discipline employees in classified positions in accordance with provisions of this charter.
And then go on to B.
And it goes on to say that city employees shall only be demoted, reduced in salary, suspended, discharged, or otherwise disciplined for just cause.
And so to follow up with the charter, the city of Knoxville has administrative rules which regulate and govern employees' conduct. Rule 11 is being provided to you now. What is this rule about?
Rule 11 is about discipline.
And so, does it discuss in 11.02E about termination?
It does.
And what does it state?
It says a senior director or director in departments that do not have a senior director may, for just cause, terminate an employee.
And go on and finish the rest of that paragraph.
Just cause may be based upon an event or condition, which is the culmination of a series of events or conditions for which disciplinary actions have been taken. Just cause may also be based upon a single event or condition without previous disciplinary actions, if the event or condition in question justifies immediate termination.
Now, in this particular case, Mr. Spence was disciplined with regard to this administrative rule 11.03. What sections did you apply with regard to his discipline?
In 11.03, there was E, violation of rules, regulations, and procedures of the department. Letter D, any legal offense depending on fine or sentence. And and in any other just and reasonable time.
So in 11.03, E, it talks about violations and rules and regulations of departments. The fire department has rules and regulations, does it not, for its department?
Yes, it does.
Did you move this in?
I handed it to you, hang on, sir. We probably should ask that each of these documents be noted as exhibits. So
Okay.
the first would be A and B. I appreciate that.
Let's look.
That's
Get your
Natalie.
little
Yes.
stickers there.
We're doing letters, so this is A.
Okay. Charter's A, and then Rule 11 will be B. And we'll ask this next exhibit be marked as Exhibit C, which is the copies of the Knoxville Fire Department rules and regulations that are applicable in this case. So you reviewed the Knoxville Fire Department rules and regulations when you were considering Mr. Spence's conduct. And with regard to those rules of conduct, what did you apply to his case?
Rule number 3.2.2, which says members of the department, whether on or off duty, shall be governed by the ordinary and reasonable rules of good conduct and behavior, and shall not commit any negligent, malicious, or criminal act which may bring reproach or discredit upon the department or city of Knoxville.
And then were there any other rules?
3.2.6, members of the department shall comply with all laws and ordinances of the United States, state of Tennessee, and city of Knoxville. At no time shall a member be ordered to violate the rules and regulations of the city of Knoxville or any other law.
So I know it's been a few years since all this first got started, but what do you recall how you first came to learn about Mr. Spence?
I don't recall who first notified me. There was probably more than one notification. Normally that comes up through the chain of command, so it probably would have been one of my deputy chiefs.
Okay, and what did you come to find out?
That he had been arrested.
I'm going to ask that this next document be marked as Exhibit D. Is this the first thing that you saw with regard to Mr. Spence and his arrest?
Yes, it is.
And can you explain to the hearing officer what this is?
This is the court document where he was arrested for aggravated assault and domestic.
And it has an explanation on the second page as to what was the arrest. Could you read the first paragraph?
The defendant committed the offense of aggravated assault and domestic in violation of TCA section 39-13-102. This incident occurred on or about Sunday, April 4th, 2021 at 01:49. Officers responded to UT Medical Center regarding a reported domestic assault. Upon contact with the victim, Lana Spence, she told officers that earlier that night she and the arrestee, Harry Spence, had gotten into a verbal argument over a text that she observed on his phone that led her to believe that he was having an affair. The argument turned physical at some point, and she said that the arrestee began to choke her to the point that she lost consciousness. For how long, she did not know. The victim had marks and bruising on her face and marks on her neck, consistent with an assault and strangulation.
Okay, I'm going to hand the next exhibit, which we're going to have marked as E, I think we're on E, to you. Was it your understanding that he was ordered to stay away from his wife following this arrest?
That's correct.
And does this document explain that? Dated April 4th, 2021. I'm sorry, you've got my copy.
Yes.
In fact, the defendant, in this case, Mr. Spence, was enjoined from being around Ms. Spence until the case
Yes.
went to court. Was it your understanding, in fact, that Mr. Spence was put in jail following his arrest?
Yes.
So once he was arrested, what did you as the chief of the department do?
I took him off the fire truck, placed him on admin leave with pay, told him to not go to any of the fire halls, and provided him with a pre-disciplinary notice.
I'm gonna mark this as the next exhibit. I'm sorry, I've got only 3 of these. This right here is what I'm gonna show him. This is it. Is this the document where you placed Mr. Spence on administrative leave?
Yes,
And what did you tell him with regard to going around the fire stations?
it says during this period of time, you're not to visit the fire stations.
Okay. And what is that letter? Thank you.
April 5.
And so you said that you sent him a pre-disciplinary notice letter. We asked this to be marked as the next exhibit G. Is this the pre-disciplinary notice letter that you sent him on April the 5th?
Yes, it is.
And so was this meeting recorded?
Yes.
And I'm gonna hand you what's marked as to H.
Yes.
I'm gonna hand you what is marked as the next exhibit, which is a transcript of that meeting. We have tape recordings of the meetings if that becomes necessary to enter into evidence at this time. The transcripts are easier to use.
Can you pause for one moment while I get
So sorry. No problem. I should have warned you to talk fast.
Okay, thank you.
In looking at this transcript, this pre-disciplinary meeting, did Mr. Spence advise you about any details of his arrest?
No.
And why was that?
He said that he had spoke to his attorney and he told him not to make any statements.
Okay. And so you didn't ask him any questions because of that, for that reason, is that
That's
true?
correct.
Soon thereafter, another incident occurred involving Mr. Spence. Is that true?
Yes.
He was arrested again. He was arrested again.
Yes.
I'll hand you the next exhibit. I believe it's I. What is this document?
It's a document that says the offense was violation of protective order, conditions of release.
And so on the second page, it has a description about explaining why the charge of violation of protective order was made. Is that correct?
Yes.
Was it your understanding after he was arrested the second time that he was put in jail again?
That's correct.
Do you know how long he was in jail the second time?
I believe he told us it was for 9 days.
So, following this new arrest, did the fire department send out a second pre-disciplinary notice?
Yes, we did.
Yeah, this is marked at the next exhibit.
DJ.
So we're up to J. Okay, thank you. So on exhibit J, is this the notice letter that was sent with regard to the second arrest?
Yes, it is.
And in the body of the letter, it explains you've been arrested once, now you've been arrested the second time, and it brought up the rules that you believed he had violated.
That's correct.
And so you in fact then met with him a second time on April the 26th, isn't that true?
Yes, I did.
And was that meeting recorded?
Yes.
In my hand. Here on the transcript, marked exhibit
K.
K. And so is this a copy of the recording from that meeting?
Yes, it is.
And so, once again, did you ask him any questions about that meeting? And that was because?
Because his attorney had advised him not to make any statements.
And so he was on administrative leave, but you continued his administrative leave
Yes, several times.
several times. I'm gonna try to hand over several exhibits, so this one could show it was extended several times. So these will be the next exhibit, I guess we could call them maybe a collective exhibit. They're gonna be 3 different dates. So we want to call this a collective exhibit N, L, sorry, for L. And so these documents show that you continue to extend his leave, is that correct?
That's correct.
Why did you have to keep extending his leave?
Well, originally we thought the court date was going to happen earlier than it did.
And in fact, the court date got postponed.
Postponed several times,
Okay.
yes.
So at this point, all you have as far as details of what had happened were the arrest warrants, and then Mr. Spence had not said anything specifically about the incident because of his attorney's advice.
That's correct.
At a certain point, you took him off administrative leave and brought him back to the fire station.
That's correct.
So he had that previous time gotten paid for staying at home, is that
Yes.
right? So when you brought him back, what did you do with him? He didn't go back to a fire truck, I'm assuming.
No, he did not go back to a fire truck. He was not to have any contact with patients, not provide any EMS, any emergency medical services. And we assigned him to one of the divisions on temporary duty, an 8 to 4:30 type job.
And his interaction in that division was how many people?
Just very few, like 3 or 4 or 5.
Okay. And that's where he has stayed until he was terminated.
Yes,
He did not treat any patients during that period of time.
not that I'm aware of.
So Mr. Spence finally did go to trial, isn't that true?
He didn't go to trial. He did have a court date. He had a hearing.
Yeah, he pled guilty.
Yes.
Okay.
I'm gonna object to leading. I try not to, but it's been kind of ongoing. I object to leading.
That is sustained.
Okay. What happened next with Mr. Spence's case?
After several postponements, he eventually had a court date in August last year.
And what happened at that court date?
At that court date, there was a plea agreement that had been reached. The judge didn't agree with it, was not willing to sign off on it because he stated that
Objection to what the judge said is hearsay.
I'm gonna hand you a document,
It's
actually.
still hearsay. We would object.
We'd ask that this be marked as the next exhibit, and our response is that the rules of evidence don't apply in this hearing. It's a civil service matter.
Go ahead and mark this exhibit here.
I'm gonna show you a document that has been marked as Exhibit M. What is this document?
this is a transcript of guilty plea dated August 31, 2023 for Harry Allen Spence, the defendant.
And if you will flip, I'm sorry, the hearing officer has the only original. If the hearing officer would flip to the last page, or second to last page, is it signed certified by the court reporter?
Yes, it is.
I apologize, our copies don't have that signed copy with the original text. And I asked, did you read this transcript when you were considering what type of action to take against Mr.
Yes, I
Spence?
did.
And I would like to ask you a little bit about this transcript. On pages 4 through 6, who is speaking in this transcript, based on your understanding?
there are several people.
I'm sorry, bottom of page 4 through 6.
Bottom of page 4 of the general cabinets.
So the district attorney's
Yes.
office. And so she's explained to the court, what is she explaining to the court at this point?
She describes some of the events that happened.
Your Honor, I understand about hearsay, but at this point, it's going to be our position, not only that we're objecting under hearsay, but Mr. Spence is being denied substantive and procedural due process by this transcript, which has hearsay statements from his wife, from the prosecutor, from the judge, which many of these people are here in the same building. It prohibits Mr. Spence from meaningfully cross-examining these individuals, and we would object to this exhibit based on that basis.
I understand your objection, but this is a document, a transcript of proceedings in the criminal court of Knox County, Tennessee. It may or may not contain hearsay. It is offered, I think, to the fact that an event occurred, that he pled guilty. There are other documentation. I think there's other documentation to that effect. So respectfully, I overrule that objection.
In addition to the transcript, I'm sorry, at the end of the transcript, on page 18, about line 13, the court is speaking. Would you read out the line 13 through 17?
It says the court, thank you, ma'am. All right, General. Pursuant to Rule 11, I don't think I'm inclined to accept this plea unless Mr. Spence has some degree of confinement. So I'll let the parties discuss that for a moment.
They concluded that hearing, and based on your review, did you see another transcript?
Yes, there was one the following month in September.
We asked that this be marked as the next exhibit.
The exhibit
In.
in. Is it Nancy?
And based on this transcript, the parties reconvened in front of Judge Sanchez, is that correct?
That's correct, and he accepted the plea agreement with some additional jail time.
He went, based on the testimony that's in the transcript, Mr. Spence was asked if he understood that no one could force him to plead guilty. I'm going to direct your attention to page 7, line 10.
Yes, it says from the court, Mr. Spence, first thing I need you to understand is that no one can force you to do what you're doing here today. Do you understand that? And the defendant said, yes, sir.
If you go ahead and read lines 15 through 21.
And the court, if you decide to plead guilty to these criminal offenses, that's a decision that you and only you can make. Before this court can accept your guilty pleas, the court has to ensure that you're proceeding today both voluntarily and on your own free will. Are you proceeding today voluntarily, Mr. Spence? And the defendant said, yes, Your Honor. The court said, are you proceeding on your own free will? The defendant, yes, Your Honor.
And so on page 11, there was some discussion about the stipulated facts that had been entered into court in August. Would you read at the top of page 11, lines 4? Actually, let's start at the bottom of page 10, where Mr. Isaac is speaking on line 25.
Mr. Isaac says.
Oh, I'm sorry, line 21, just so we get the full conversation.
The court, All right, you're accepting the stipulated facts that were set forth by the Attorney General in the previous court setting with regard to this case. Mr. Isaacs, Your Honor, we would agree that they are the stipulated facts, but we would object in terms of their veracity or whether they could be used in another proceeding. The court, all right, are you stipulating that he committed criminal offenses that would support reckless endangerment, a Class A misdemeanor, as well as harassment, a Class A misdemeanor? Mr. Isaacs, yes.
And so after the court accepted his guilty plea, and they determined confinement for 10 days, if you'll flip to page 11, what did the judge say with regard to Mrs. Spence on line 3?
What page?
Page 13.
You said you're ordered to have no contact or threatening behavior with Lana Spence outside of custody exchanges and or orders of the Chancery Circuit or Juvenile Court. An added condition of your plea is that you are to surrender yourself for the next 5 weekends to serve 48 hours on each of those weekends in the Knox County Jail. And he says that's at the Roger D. Wilson Detention Facility. That'll begin on the 22nd, so this Friday, the following Friday, the 6th of October, the 13th of October, and the 20th of October.
So in addition to the transcript, you saw a number of court records with regard to his guilty plea.
Yes, there was a judgment
Okay.
that was provided.
I'm gonna ask the hearing officer, enter into the next exhibit. Are we at O? And these are 4 pages. One's labeled count 5 and one's labeled count 6. Did you review these 2 documents when you were
Yes.
considering what to do?
Yes, I did.
Okay. They're gonna be collected.
Collective.
Yeah, just mark it those.
Oh, sure.
And so, count 5, what did he plead guilty to in count 5?
Reckless endangerment, a Class A misdemeanor.
And then on count 6, what did he plead guilty to?
He pled guilty to harassment, also a Class A misdemeanor.
And so, with regard to the special conditions, on the page 2 of each of those counts, what did the court order?
Under the special conditions for the count of reckless endangerment, it says by authority of TCA 40-35-306, the sentence shall be served in periodic split confinement as follows. The defendant shall serve 10 additional days in the Knox County Jail over 5 consecutive weekends, beginning 9/22/23 and ending 10/22/23. The balance of the sentence shall be served on probation. The suspension of the defendant's sentence is conditioned upon his not hereafter violating any laws of any city, state, or of the United States, or being guilty of any misconduct inconsistent with good citizenship. It is further conditioned that the defendant shall pay the cost in this cause.
And it also included the no contact order.
Yes, it says the defendant is hereby enjoined and restrained from contacting or attempting to contact the victim, Lana Spence, or her immediate family, either directly or indirectly through third parties. Such contact includes, but is not limited to, phone, text, social media, email, postal mail, or any other type of communication or contact. The defendant shall not come about the victim wherever she may be for any purpose. Defendant is specifically enjoined and restrained from engaging in any further assaultive, harassing, or intimidating behavior or otherwise interfering with the peaceful living of Lamastans.
And if you read that last line as well.
Contact with the parties, minor children shall be governed by the order of the court having jurisdiction over custody of said children.
And Mr. Spence told you that he had pled guilty willingly, did he not?
Yes, he did.
I'm going to show you the next exhibit. Is it?
Yes, it is.
And does this document show that he waived his right to a trial?
Yes, it does.
And is it signed by Mr. Spence?
Yes, it is.
Would you read out loud paragraph A for the record?
It states that I understand that if the court accepts my plea of guilty and I am convicted of the offense to which I am pleading guilty, these convictions will be public record, may render me infamous, denying me access to the elective process and making my sworn testimony subject to attack, and may be used to increase the punishment I might receive if I am later convicted of any crime, and may be used in combination with other felony convictions to establish the status of career criminal if I am later convicted of another felony.
So in addition to the transcripts and the judgment, there were exhibits entered into the court record. Did you review the exhibits from the court record?
Yes, I did.
Okay, I'm going to ask that these next exhibits be marked. I only have one color copy, so we'll have to pass that back and forth.
This would be Q. You making this a collective exhibit?
I believe so. I think that might be easiest.
You want me to mark each page?
Yes. So,
You all may already have copies of the colored photos. You have
We
black and
do.
white copies. Mr. Sharp, did you review these photos when making your disciplinary decision?
Yes, I did.
And based on what Mr. Spence advised you in the pre-disciplinary hearing and what the evidence showed in the transcripts, what are these photos of?
These are photos of Lamastans' head and neck that were taken the night she was taken to the hospital.
And so what do those photos reflect with regard to her head and her neck?
So
Objection, the photos speak for themselves.
sustain.
Do you see marks on this
Object
Spence's
leading.
neck? I'm asking a question. You may or may not see that. Do you see marks on Mr. Spence's, or Mrs. Spence's neck?
yes,
And do you see marks on Mrs. Spence's forehead?
yes.
Okay, you can't sit here. You're gonna have to move because I need to be able to see my friends. Thanks. So another exhibit that you observed and reviewed, and I apologize, I have copies, but I only have one stamped version. We'd ask this be marked as the next exhibit. These are text messages that were also introduced into the court record or the criminal court record.
Exhibit R.
Did you review this? I'm sorry. Did you consider this exhibit that was part of the court record? And then hand it back to him.
Yes, I did see it.
And then finally, from the court record, we asked that these next exhibits be marked as a collective exhibit.
Yes.
Exhibit this.
And these were entered into the court record as an exhibit in Mr. Spence's criminal case.
That's correct, and I reviewed them.
And what are these records?
These are the medical records from Lana Spence that night she was taken to the hospital.
And so because they're rather lengthy, I'm going to ask you to direct your attention to some specific pages in the record. Let's start with page 3. Middle of the page, there's a portion that's marked history of the present illness. Can you read that aloud for the record?
Yes, it states that the patient here, after unexplained event, she has facial plethora. Report was from EMS to nursing staff, as well as husband stating that he did not know what happened. She suddenly started choking. No history of seizure disorder, no history of trauma, no history of cough, cold illness, no history of any complaints prior to this event tonight. She currently denies any injury. She admits to 3 drinks tonight, denies any drugs. She reports that she briefly could not see when she came to and was choking and vomiting, and she was given Zofran by EMS en route.
I'm going to ask you to look at page 4 and read aloud for the record the progress notes.
It states that husband was removed from the room. Certain aspects of the history was not completely logical. Patient is asked if she feels safe at home, replies she does not, and she is even more worried about her 5 kids at home. There have been issues in the past, but nothing like this. She is concerned that he attempted to strangle her. She would like to make a police report. Security was consulted for additional help. Patient was evaluated by police, and patient had a safe disposition home with family. Significant other has been taken to jail. She had been monitored here for a number of hours. Her GCS remains 15. Her repeat full neurologic examination shows no acute lateralizing deficits. There is no ataxia gait and station normal. Her CT scan with, without, and CT angio head and neck unremarkable. There has been absolutely no deterioration. Her potassium returned low at 2.9 with no EKG changes. She has family in the room. She feels safe with him, comfortable going home with her. Patient is discharged to safe place, discussed in detail what to watch and return for.
Now if you'll flip to page 8. And then about the top corner of the page, there's a nurse's note. Could you direct the court's attention to that note?
Yeah, the nurse note says patient SO, significant other, what that, my understanding what that means. It states that he awoke the patient screaming. It states they were asleep on the couch, contusion to and petechiae of left eye from possible fall for EMS. Neither patient nor SO know how injuries to left eye occurred. SO core historian, AMS on scene per SO, patient AOX3 at time of intake, half-act flat.
So now I'm going to ask you to turn to pages 73 and 74 of the medical record. And I noticed there's a chronological order, but it's sort of reverse. So can you look at page 74 first? What time is the first note on the chronological order?
0031.
And what does that say?
It says, has husband at bedside with patient, patient denies wanting husband to leave. Husband continue to answer most information questions for patient. patient appears in NAD, non-labored respirations.
And so then we're moving to page 73 because it's reverse chronological order. What was the next note in the record, in the file?
There's still one on
Oh, I'm
page
sorry.
74 at 0045. MD O'Brien at bedside, husband also at bedside. And then at 0059, patient's blood samples collected, central lab for orders. Patient somnolent, denies further needs, but requests water, blanket provided also. And then it goes on at 0100, MD O'Brien requests patient's family member step out for individual assessment and physical assessment, patient agreeable. At 0101, writer requests husband step out of the room. Husband states, no, I think I'm fine, I'll stay here with her. Husband informed of patient's need for privacy during the examination by MD. Husband agrees to step out. MD O'Brien to bedside for the rest of the exam. And then at 0115, TL made aware of possible abuse situation with family at bedside. After speaking with MD, decision was made to handle the matter.
Your Honor, at this point, I understand that hearsay can be admitted in a civil service proceeding, but now we're getting into hearsay within hearsay, and we would, again, object. There are no live witnesses that are subject to cross-examination, and we would assert Mr. Spence is being denied substantive and procedural due process.
We have the record here that's been admitted into the evidence. I don't know that it's necessary to read. The record.
Okay. And we would, as far as the rules and substantive of his argument and objection, he had an opportunity to review these records and speak to Chief Sharp about it, which is what the civil service rules require. When he met with Chief Sharp, he had an opportunity to speak to him about anything he wanted to talk about with regard to this incident. He did not want to talk about the medical records. He didn't want to look at photographs. We gave him additional opportunity, and the proof will show that he could submit.
No, why don't you ask the chief about that?
We will,
And,
but he has had substantial
well,
procedural due process with
That
regard to
was
these
my
documents.
objection.
I understand Mr. Isaac's objection, and it's sustained. But you may ask Chief Sharp questions that you indicated that he could provide answers to.
Sure. This document was submitted as an exhibit in the criminal court case, is that not true?
That's correct.
And did you review this
I did
as part
review
of
it.
your disciplinary decision?
Yes, I did.
Did you talk to Mr. Spence in the pre-disciplinary meeting about these exhibits?
They were provided to them. We provided him that along with the photographs that were given.
And he had an opportunity to tell you anything he wanted to say with regard to these?
That's correct.
And he actually had additional time?
Yes, we gave him, throughout that hearing, we gave him a chance to respond and to tell us anything that he wanted to say. And at one point, he asked for additional time to provide additional evidence, and we granted that. So I believe it was a little over 2 weeks to provide whatever he wanted to provide.
In addition to these court records, what else did you review before making your disciplinary decision?
Also obtained and reviewed 2 body cam videos from police officers who were there at the hospital that night.
Can you hand me that document that's inside? We're gonna ask that these tapes be entered into evidence. The next exhibit is the affidavit showing that these tapes are the sheriff's videos from that night in question. They're rather lengthy. However, we've cut it down to about 30 minutes, different clips. There's 2 different tapes in question.
Well, I'm going to object based on there's no evidentiary foundation. this, even though hearsay is admitted, this is the proper way to lay a foundation for edited body cam.
We're not editing them. The whole tape is on, the whole thing is on tape.
Well, again, we have an affidavit of Johnny McDonald. It's, there's no sufficient foundation. I mean, if we're going to have, all of these, just because they touched a criminal court file, then, there is no ability to cross-examine or requirement to lay foundations. This was not part of the criminal court file. And the appropriate way, if it's going to be introduced in the hearing, I think, is to lay a foundation from the officer regarding body cam. Obviously, they know there has to be a foundation, or we wouldn't have the affidavit of Johnny McDonald. So we would object and respectfully say this is not the appropriate way to introduce these body cams.
The city's position is that we do not have to have this, but the hearing officer at the last motion hearing asked for us to provide certified copies, so we endeavored to get certified copies. These are the same videos that Mr. Spence was provided prior to him submitting information. The video is actually of Mr. Spence, so Mr. Isaacs has the ability to question his own witness if he wants. His client, it's a video of him and his wife. And we believe that because Chief Sharp considered it, it's appropriate for this hearing.
That's what wasn't the basis of my objection, but if the rule is for this hearing, if we decide to go, to Chancery Court, everything comes in because he may have looked at it, touched it, whatever. This is not the appropriate way when you look at the rules and regulations for administrative hearings to get in a body cam with a hearsay affidavit. Just because Mr. Spence was given this body cam doesn't mean that ergo there is no foundational requirements in the future. We would strongly object. This is not the appropriate way to move these items into evidence.
These are business records of the sheriff's office. Civil service rules are clear that we do not have to provide certified copies. We don't have to have, hearsay is admissible. Certainly if once the hearing officer sees the cameras, then he's gonna see that they're not interviews of the police officers. Obviously, there might be an issue if it was, but in this particular case, it's Mr. Spence speaking and Mrs. Spence speaking. And because Chief Sharp considered it as part of his disciplinary decision, it's appropriate for this hearing officer to consider it.
I'll overrule the objection. We'll look at the video, and Mr. Spence can be asked about the video. Frankly, the chief can be asked about the video, I suppose, if he has any first-hand knowledge of the video.
So, Mr. Isaacs, we have segments of the tape that we plan to show. We certainly are happy to show the entire thing, or just like with the medical records, we can admit it to the hearing officer, but because there are certain pieces of it that are important for Mr. Chief Sharp to explain, we think that it's appropriate to show these clips. There's a 6-minute clip from one video. The only reason we're not using just one is because of the sound quality. There's 2 different perspectives from the officers, which you'll be able to see, but it's the same, basically the same. So if you don't mind, Chief Sharp, would you pull up the UT medical tape?
I would object to having a redacted body cam. Is this going to be an exhibit?
We're asking
But
that
the
these both be marked as the next exhibit. They're not redacted. We simply propose playing a small snippet. You're welcome to play the rest of it if you want to. We just don't want to take 2 hours of the hearing to play the videos. They're not redacted in any form.
Are you representing that is the full body cam video taken by
There's 2 different.
apparently the Knox County Sheriff's Office personnel
Yes,
on April the
it's
4th?
late night, 3rd, beginning of 4th. I think the video starts on the 4th, midnight. And it's the complete incident. from the moment that they saw Mr. Spence. The videos show the complete incident from Mr. Spence being spoken to until he's led to the police car. We weren't going to show the entire thing, but we are happy to if that is what Mr. Isaacs wants.
What's the affidavit? It's T. And the video will be you.
And so the thumb drive, there's a thumb drive that Mr. Roach was provided last week as part of the brief, which I presume you haven't seen yet, but the thumb drive, it has both of these on it. We
So
have
the
CD.
exhibit will be the thumb drive.
I think that's the best way to market it. You can play the first one, the medical center video. Your sound is not on yet.
The sound doesn't come on initially.
Elena? How you doing? I'm Ross Off from Mustang County Sheriff's Office. Can you tell me real quick what happened?
Nothing's going on. Invested indicated that he's a junior, yes, and, I asked him that. And, then, during the week, we got a house. And told me about it. He said, my kids look up because they're asleep. And, then that's when we told him to get out and figure out things and put me in a rental picture.
Okay.
I don't know how my face, I don't know if it's forward, something in that, and then I was very confused when I came to.
So you did lose consciousness? Okay.
I didn't know how to talk to it, and I was panicked. I told them, I told Jasmine my past, I told her everything I'm trying to do, I told her, but
Okay. Do you have an idea of how long you were out?
I mean, I can't imagine it had been that long, but
Who drove you to the hospital? Ambulance did? Did you call? He did? Can you look up at me so I can see your eyes? Okay. And all the scratches on your face and nose, of course, marks around the neck, of course, came from him.
Do you remember fighting or anything before he put you in a jungle?
they're really fighting myself to get out.
That's it.
Okay. How many kids do you have at the house?
I left the house around when they're flying.
Do you have somebody en route over there to take care of them? Excuse me, ma'am?
Charged her, her name's Tanya, she's trying, she's working on it.
Okay. How old are they?
There's somebody that's there, I just want my brother, that he's, has my brother and my sister-in-law, So I'm wanting to come get them, but there's somebody to stay with them, so they're all on there, so they're okay right now. I just don't want him to, I don't want him to go home. That I think is what really escalated, and I said they were yelling.
So we're gonna sit on here and go to.
And I told him, you wait a second.
Were they in bed? Did they see any of that?
Remember coming to like that, they were asleep, and I saw something be quiet, and they were quiet, they got more quiet, so. And, I was screaming. When I woke up, I was screaming.
Okay. Do you, have y'all, ever had reports done for domestics prior to this?
You must have been that
I didn't have any.
Okay. What's a good phone number for you, dear?
I don't have it right now, but it's only 865.
86. Let's say it's every morning.
That's something to do.
Are you working right now? Where are you working at? Carson Newman? What do you do there, man? Teacher. And good social for you? Okay. And your husband's outside the lobby right now?
What's his name?
It's Harry Spence.
Harry.
And his date of birth? And your date of birth? 6. Alright. We're probably gonna have our forensic unit come out, take some photographs of your neck, okay dear, and your face. And we're gonna go speak with your husband real quick, okay? Okay.
So this tape continues and they walk down the hall. We propose to move to the other tape just because of sound purposes. He stands closer to Harry. You'll see there's 2 officers. So unless there's any objection, we would flip over to the next body cam, which is the Axon body tape.
Just the same objection for the record.
Go ahead. Can you stop this tape and go to the next tape?
You're not 0149.
So this is where we stop this tape and go to the next tape so it shows Harry Spence closer and it sounds better. And you can fast forward to 2:09. So we're just fast forwarding through what we've just seen to 2:09 where they're walking down the hall. You can go back just a little bit. There you go. You may need to go back to make sure the sound works.
Where is Mr. Harry? Where is Mr. Harry?
Husband, ready for you? Okay, I mean, you've seen him? Yeah.
Well, pretty straightforward.
Yeah.
Just go ahead and come. Good, how are you, man? You seen that home real quick? Yeah. Turn around, hand on back.
Turn around, fix it.
While we're here,
Yeah, right here.
we were sleeping and my wife went down, and so my son woke up, I went over and checked on her, and she started sneezing or doing something, panic attack or something.
She did what?
Was having like a panic attack, seizure type thing.
Okay.
And our daughter, and actually our son's on his way right now, and my son-in-law's on my way to get me something in my car, so he'd come back and get us, but they heard us, and I went downstairs and got them, and called dispatch because of KFB, and asked them to send me an ambulance, because I was worried about her.
Can you explain how your wife got marks around her neck and all over her face?
Well, my guess is on her face, and whenever she did the little thing right there, I'm guessing when she went down, her neck, I don't know about her.
What little thing?
Little stand on there, right behind the couch. You know, my gosh, she went down.
How does that explain the marks around her neck?
Don't know anything about that. I've been there the whole time, and there was no marks or anything when I was there just now.
So you said stand behind the couch? Behind the couch?
Yeah. So we have an L-shaped couch in the middle of next to it over there.
What were you saying?
We were laying on the couch. Me and my son and her. She got up. I was laying with Teddy. He was on this side, I was on this side, she was here. We heard her, got up, looked, and that's when I went over and checked on her. She got worried, ran downstairs, got my daughter and them come upstairs, called dispatch, asked them to send an ambulance.
Where's your son?
And he's looking on his way to get me.
How old is it?
I believe he's 26, he's my son-in-law, I just speak to
He was
him.
there.
Yeah.
He was there with you in the
No, him and his wife are downstairs, so we have 6 kids all together. They are staying with us, our grandson, grandbaby, they were downstairs. So she went down, I went downstairs, got them, asked them to come up and help me.
What child was with you?
They was on the couch.
How old?
They stopped.
5.
Yeah, he stuck on the couch with us.
And he's at home with the other brother?
He's at home with my daughter, my 24-year-old daughter.
What, who's he home with?
My 24-year-old daughter.
Where was she at? Y'all didn't argue or anything? No?
So what you're telling us is that you were not in an altercation?
Not when all this happened, no. No, we had a great through darts. Talked about the whole fire department thing. We talked about that, and then we laid down. And then she got upset and got up, and that's when I saw her down when we were laying on the couch.
What she got said about?
I don't know what she had upset about.
So y'all were just sitting on the couch and she just got
Laying
upset?
on the couch.
Y'all were saying that y'all were sleeping?
Oh, you're going to sleep on the couch. I was laying here, Dave was laying here, she was laying next to me. We're in the process of going to sleep. I was laying there with him, we heard her go down, that's when I got up.
What do you do for Kennedy?
I work over at Station 17,
As a,
firefighter, senior firefighter.
which one of these phones are
It's that one right there.
you? This one?
Yeah.
Is this one belongs to what?
Yeah. That's our gate opener up there. In our house.
Well, there's just some things that aren't adding up as far as the market.
And I mean, you can ask her whatever we need to do, it's fine.
Do you have issue with
have nothing, both of us have to go.
Have you all gotten the good bargaining support?
Oh, yeah, everybody's in the family, heck, we've been together 12 years.
And I agree with you.
Yeah, we've gotten arguments before. Never physical, no, we've never had to report anything, no.
So nothing ever physical before? Just all verbal?
Yeah.
Alright, it's just,
No, it's fine. Like I said, I work with AFD. She's at Carson Newman. My mom works over at Avon Bonding, so I mean, you can check anything you can check.
they could be here for a while.
Yeah.
Yeah.
Call this number right here. Thank you, Jack.
You got an audio on your phone?
Yeah.
Is it your back pocket?
You know what?
Is it in your back pocket?
Nah, he's on your phone right there. No, that's fine. That's what I was asking.
Well, I wanted to come out and speak to you and see what you had to say about it.
Very fine.
Well, you know, that just
Yeah, I agree.
snap photograph of it, send it to me. Yeah, work out the rest of the notes. Okay, what's the city name?
I'm sorry, what?
The city's name is what?
Fort Knox, Kentucky.
What's his line for you?
865.
And what's your social?
255. Flip my phone over just in case my son calls when he gets here, just so I know that he knows what's going on, because he's going to be out there again. Like I said, he was going to come get us, or come get me, so I can go back and get the car and come back and get her.
So, when all this happened, was it just that one kid that was around?
Yes.
What's his name?
Where are the rest of the people at?
In their beds.
What's his last name?
What beds?
Spence? What's his birthday? And where do you go to school at?
I'm assuming you contacted it. No.
No, we rode in the ambulance, you know, like I said, I'm worried about it, so we were together. Like, literally.
What grade did you go?
Kindergarten. I'm the one that called the ambulance for it and got worried, so literally I rode with her here, and that's why he was coming to get me, so I get my car and come back and get us. But, yes, now this is how I got kind of see why. She said that I did something, or just, this is forensics, like you guys are saying, because you see marks on her face and the neck or whatever.
No, she said you took her out. So did you? So again, how did she get the marks on her neck?
Like I said, I've not seen any marks around her neck. And when we're in Anchorage, she didn't have any room. And she had a mark on her nose and her eye where literally she was not a thing. And I'm guessing when she went down, she hit her face. That's it. I didn't know anything about marks on her neck.
So y'all didn't argue anything physical at all? It's a little weird that you would say that.
Literally, I'm the one that called dispatch for her.
I mean, people can get mad and then realize what happened and still care about the people that, what happened to them.
They did, Mark, correct?
Has she ever made, these allegations against you before?
No, we've never had any problems like this.
I mean, is there a reason why would she say
I guess you gotta ask her.
something like this?
He was in route to the house.
Like I said, my daughter was there already.
How old?
Oldest daughter, she's 24.
24?
Yes, and her husband is on the way right now to get me, and that's why that's flipping over so I can go home and get my car and come back and get her, but I guess that ain't happening.
She's 43 and we'll do with that.
24.
Hey, over 18.
Over 8.
Over
Yeah,
18.
she's over there. Alright, I'm gonna wait for the ladies to get here. What you want to know?
What is wrong?
That's it.
How's it working?
No, I after maybe get done. And then, we'll that stuff there. Do it again?
Yeah.
I'm gonna go back on her, give her a call.
No, no.
And this is her phone, correct?
Yeah. So have you ever had anything, been involved in anything like this before? And they kind of let you know before they tell you down at jail, it's a little easy for me to tell you. So you go down there, been on a 12-hour hold, but when you come out, you will have to sign a paper, it's called a conditional release, saying you can't go back to the house or be around her until you're court date. I don't know where your kids live, the older ones that don't live with you,
We all in the house.
your, who did you say, your brother-in-law or son-in-law?
Son-in-law's coming through. Him and my daughter were in the house with all of our other kids.
Well, you have somebody else to stay with until your court date. I guess. I don't know what happened, but if you get out of jail, I don't know,
Yeah.
between y'all.
You gotta see my phone, I think it's calling me just so I can tell them what's going on.
Boy,
Yeah. Here, I'm just moving my hands around, but that's alright, so I can go.
I'm out told up there, so.
Let's go.
I mean, if he needs to bring her in.
Hey, go ahead and head back to the house. I don't need you, buddy. I appreciate it.
Hey, you gonna go back to your house?
Nah, don't worry about it. I appreciate it. Just watch the boys until Lana gets back, okay?
Oh, man, I'm out here.
I know. I gotta go, buddy. I appreciate it.
Yeah, here you go. Thanks. Where y'all live? Over here? That's a long drive, Bonnie Cave.
That's where we live at.
Oh, Bonnie Cave.
Yeah, it's not that far.
No, I got all mixed up. For some reason, I'm thinking, Ricky. Oh, something. Yeah. No, never.
It's a long time.
Not really. Just one of those times, you know?
So if I'm not allowed to go to the house, how do I get my car?
Get your car?
Yeah. Like my cars are at my house.
You can get them on your son-in-law, your daughter, or somebody. Bring clothes, bring whatever you need. Or you can call us and set up a standby, so we go over there with you. Just to keep you from.
Can I call in real fast?
Get you and.
Can I call my chief real fast, just let him know I'll be there? I don't need to always do that, so I'll do that. Yeah, or I'll just text him, can you just line up me out for a second, I'll just text him real fast.
Open that up. Oh, okay, don't do that.
Well, I need to text him.
Okay, you can. Yeah, I
I can't.
just open it up.
For what?
I mean, I'm helping you out as much as you can.
I just need to text him so I can tell him I'm gonna be there. I need a check. So do that.
Okay. What are you gonna say? Ain't gonna be there?
Yeah, gonna take 24 hours. Yeah, just text me.
There you go.
Just
Okay, you're gonna figure out how to do that?
Sick.
24 hours, I said.
Yeah.
There you go.
And then I gotta text, well, I gotta text my captain test as well, tell him my captain.
Is that your chief?
Yeah.
He can let your captain know.
I gotta let my captain know. Like, that's how it works. I gotta let my chief and my captain know that I do. If you don't mind, please, that's just how we do it. I gotta let them know if you don't mind. And I'll show you the other one. I should let them know.
I mean, your chief can't let your captain know?
Well, if he's off or something, so the chief fills the watch out. I just need to let my captain know as well, if you don't mind. I'll show you his Dustin Bull. I just need to let him know as well, if you don't care. Just trying to make sure everybody knows that.
I mean, I get it. I mean,
That's just
I'm trying to help you out.
I know, and I know.
We ain't texting your whole KFP.
Well, I'm not. I'm texting two people. I'm texting my captain and my chief.
Yeah, let's do what. You're still going to jail right now. Most people just don't get like taking.
Well, I understand that, but I appreciate you helping me. But I've got to let them know because I have a job. It's ones. It's all ones.
What in the world is it worth having a passcode if it's all ones?
Because sometimes it just dials random.
Because I bet you I could sit here and I could figure that out.
100% you could. So scroll down and hit that.
This one right here.
Where you hit that one? Just pull BULO.
There you go. Yep.
And just say I'm 24/6. Yep.
Alright.
Thank you.
There you go.
So I don't have to bond out or anything like that. I'll just have a 12-hour hold.
Yeah, have a 12-hour hold. You'll be arraigned. They'll be able to tell you more about it. They'll be able to tell you the specifics on what's going on. I'm not sure when your court date will be. They'll give that to you whenever you get around. Y'all been drinking tonight or anything?
Yeah, that's a beer.
How long you say y'all gonna do it? 12 years?
12 years.
Nothing like this has ever happened?
Married for 11.
So you potatoes and not let that stuff happen. Because right now we're getting two very different stories. How long ago was KFC?
Let's see here. Well, actually, it's a couple other years ago. April 10th will be Olympics, or April 12th. 4, 10, 12. 4, 12, 10. Sorry, 11 years. We got married in 9 and then started working on it.
You said all your kids were just in bed? So you said she fell. When she fell,
That's what.
so you came around the couch. Was she conscious?
Lost consciousness. I mean, she was breathing and everything was in her face now. Making them scream anyways. I was screaming, I was screaming like noise. So she couldn't breathe, and she said she couldn't see.
Chief Sharp, did you watch this tape as well as the other video in its entirety
Yes.
prior to making your decision? Prior to making your
Yes.
disciplinary decision? We would ask the hearing officer to take the opportunity to review the entire tape in consideration, but obviously, at this point, I think we've covered most of the substantive issues from Mr. Jones. You had a third and final disciplinary hearing with him, did you not?
Yes, I did.
Is this a copy of a pre-disciplinary letter for that meeting?
Yes, this is it.
Was that meeting recorded?
Yes, it was.
Did you get
So
the
we'll
letters?
mark,
I'm sorry.
the October 13, 2023 letter as B.
V is in Victor.
B is in Victor.
Thank you.
That was October 13th.
And you got a transcript there, we'll make that BBW.
What's transcript?
The transcript is W.
Oh, of this, okay.
Yeah. It's October 24.
You have a copy of that transcript in front of you. Do you not? The 24th. I'm sorry, this will be your.
And the letter. Are we marking that separate from the transcript or what?
The, as in the,
Oh, I thought that was, okay. Okay,
this is my stuff.
I'm with it now, thank you.
Thank you.
And where the exhibits marked, this is, I'm sorry, the tapes marked as exhibits, that's gonna be the thumb
You.
drive.
Yes.
It's you.
Okay, just making sure we hadn't missed it. With regard to this pre-disciplinary meeting with Mr. Spence, what is the purpose of having the pre-disciplinary meeting?
To give, Harry a chance to respond, and to tell me his side of the story.
And so you all discussed the incident to which he pled guilty to,
Yes, we did.
and so after showing this tape, were there discrepancies between what he said at that pre-disciplinary meeting and this tape recording that you just showed?
Yes, some of the discrepancies were that, he said that, they did not have an argument, or an altercation. He said that he didn't know what she was upset about, and he said he didn't know what happened to her, that he was asleep, she went down, and he woke up and went and checked on her. At the pre-disciplinary meeting, he said that they had an argument about a text, and that he admitted that he pushed her. There was also on the tapes, multiple times he said he went and checked on her, that he got worried about her, so he called an ambulance. And during the hearing, the pre-disciplinary meeting, he stated that she was fine, she didn't need to go to the hospital, she just wanted to go to the hospital.
With regard to his description of what happened to her and how she got the marks on her, what did he say at the pre-disciplinary meeting? As far as, did he have an explanation for the marks on her neck?
The best I can recall, he did not have an explanation for that.
What about, did he acknowledge that he had touched her at the pre-disciplinary meeting?
He admitted that he pushed her.
At the conclusion of this meeting, what did Mr. Spence ask of you?
He asked for some additional time. He said that his attorney had some documents or some information that he could provide, disputing certain things. So we gave him an additional approximately 2 weeks to provide whatever he wanted to provide.
I'm going to hand the hearing officer the next document to be marked as the next exhibit. And this document that's got the heading, Isaac's Law Firm, this was everything that Mr. Spence and his counsel provided to you for your consideration.
Yes, this was all that was provided.
And did you review it and consider it?
Yes, I did.
So would you explain to the hearing officer your process for how you made your disciplinary decision?
Okay. After we received this, I went through all of the information I had, all the documents I had, which would include the original arrest warrants. I reviewed the city rules, KFD rules. I reviewed the transcripts from the hearings, the pre-disciplinary hearings. I reviewed the court records, which included the judgment. The transcripts from those 2 dates in August and September. I reviewed this document that Mr. Isaacs provided. I also viewed the body cams, and then I came to my decision after reviewing all of that information
And what was your decision?
that Mr. Spence should be terminated.
How did you notify Mr. Spence of his termination?
We notified him in writing.
And the hearing officer, the next marked exhibit, or the exhibit to be marked.
Okay.
And I apologize, we appealed a lot of treaties for this hearing. We did not attach all of the enclosures that were provided to Mr. Spence. The documents were provided, and there's a mention that there's enclosures. But we did not make copies for that today. And what was this letter that was written on November 21st? What did that letter say?
This is the notification that his employment with the fire department had been terminated. And it goes into the actual reasons that he'd been terminated, all of the violations.
So, can you explain to the hearing officer, and I'm gonna place these rules that we've admitted into evidence earlier as exhibits B and C in front of you. Can you explain to the hearing officer, how Mr. Spence's conduct violated, fire department rules and the city of Knoxville admin rules?
Okay, the first is from the KFP manual of policies and guidelines. It's rule 3.2.2 that members of the department, whether on or off duty, shall be governed by the ordinary and reasonable rules of good conduct and behavior, and shall not commit any negligent, malicious, or criminal act which may bring reproach or discredit upon the department or city of Knoxville. Obviously, he violated a rule of good conduct and behavior. This is not exhibit good conduct and behavior, and he pled guilty to a criminal act. And then 3.2.6 states that members of the department shall comply with all laws and ordinances of the United States, state of Tennessee, and city of Knoxville. He pled guilty to violation of state law. And then city admin rules, 11.03 E states the violation of rules, regulations, and procedures of the department. I just went over those 2 that he violated. G states any legal offense depending on fine or sentence. We just went over that he pled guilty to 2 different charges. And in any other just and reasonable cause. And I think that based on all of this information, that he pled guilty, and all the evidence that I had, that this was just cause for terminating his employment.
So, obviously, there's just cause for discipline, but why did you decide on termination?
Because these are very serious charges that he pled guilty to. Reckless endangerment, and that ended up Ms. Spence having to be evaluated and treated at the hospital. And so I have to take that very seriously.
Did he end up going to jail for this?
Yes, he did. He had to serve an additional 10 days in jail as part of his sentence, as part of his plea.
Was this the first time you had met with Mr. Spence regarding the disciplinary matter?
No, there was one other time in 2015 when he had been accused of inappropriately touching a female firefighter, which he eventually admitted to. And after that, he had to undergo harassment training.
I'm gonna provide the next document to. Did you, I'm sorry, with regard to Exhibit Z, oh, I'm sorry.
Z.
I'm gonna show you Exhibit Z. What is that document dated December 22nd, 2015?
It is notice of a pre-disciplinary hearing set for Thursday, December the 24th.
And is this the previous incident that you were
Yes,
testifying
it
to
is.
earlier? Was that meeting recorded?
Yes, it was.
Well, we're out of letters.
So, go to AA.
Is Exhibit
That's why
AA,
sometimes the numbers are better.
is this document that's been marked as Exhibit AA a transcript of that meeting?
Yes, it is.
And you all discussed the incident that occurred back then.
Yes.
Did Mr. Spence acknowledge his behavior at that meeting?
Ultimately, but he went back and forth, said he did it, he didn't do it, he did it, he finally admitted to doing it.
That would be BB.
I'm showing you what's been marked as Exhibit BB. Do you recognize that document?
Yeah, this is the document where he admits to inappropriately touching another firefighter. Female firefighter.
Did you all take disciplinary action with regard to Mr. Spence after the previous 2015 incident?
He was provided with a counseling form and he was required to undergo harassment training.
No. Next. Does this document that I just handed you, which I think is going to be marked CC, reflect the action that was taken against him in 2015?
Yes, this is it.
And so he had received additional training with regard to harassment.
Yes, he did. As a result of this incident, he had to undergo additional training, which he did.
And he was allowed to stay with the department.
That's correct.
Is there anything else you'd like to tell the hearing officer about why you made the decision to terminate Mr. Spence?
Yes, I take these matters of discipline very seriously. I'm a very fair-minded person. I take the protection of our customers, which are our patients, and my firefighters seriously too. I feel responsible for their safety. I feel responsible for the reputation of the fire department. And I don't take these matters lightly, especially when it involves termination. But I believe that based on him pleading guilty to these very serious charges and all the evidence that I had, I felt like I had just cause and it was the appropriate thing to do.
Since Mr. Isaacs has some witnesses on his list with regard to an email that you received before we get into that issue with them, did you consider the email that Mr. Isaacs is talking about as part of your disciplinary decision with regard to Mr. Spence?
Well, object, the record is not clear on what email Mr. Isaacs is referring to. There are a number of emails.
No clarify.
I believe you mentioned prior to the beginning of the hearing that it was a Jemina plant. I think you
Yeah,
said
if you want to
plant.
see the email, that's,
I'm sorry, I thought you already had it.
well, I'm just making sure that you're referencing the one that I did in our, I think we were off record, on record before we began.
That's the Lenny Blair email, and this is the Jemina.
That is one,
Is that the
the
email?
one with Ms. Plante that I referenced.
You said the emails are you better copies. So Mr. Isaacs brought up that prior to the hearing starting, some emails that were received from female firefighters from the fire department. Did you receive copies of 2 emails from Ms. Jemina Plant and Lenny Blair?
Yes, I did. So what I did with those, I forwarded them to the law department and then also forwarded them to the civil service department because some of the things that were said in there, that's what would have been required of us is to hand it off to the civil service department. And so that's what I did with both of those emails.
Did you?
And then I responded back to them and told, I responded back to both of those emails and basically told them that it would have been handed off to, like this one says, advise Director Hatfield of your concerns in accordance with city administrative rules.
Did you consider this, either of these emails or any of the information within those emails as part of your disciplinary decision?
No, I did not. I handed it off to civil service to deal with, and then I went back to dealing with what I was already dealing with Harry's actions.
Thank you.
Are you wanting to make these exhibits?
I don't know if Mr. Isaacs does.
Okay. You finish your director's
I'm finished.
I think it would be a good idea.
Thank you.
We'll take a recess. Okay. Mr. Isaacs, you're up.
Good afternoon, good morning, Chief Sharp. My name is Gregory Isaacs and I represent Mr. Spence. Now, you first became aware of Mr. Spence's arrest on April 4th, 2021, almost immediately, correct?
That's correct.
And at that time, as the Knoxville Fire Department Chief, did you review the charging instruments that have been previously introduced, the 2 Sessions Court warrants, the original ones?
Yes, I did review those.
And I think Exhibit D is the aggravated domestic assault warrant, correct? We talked about that during your direct examination. And this is a copy. I want to make sure.
This is the aggravated assault.
And in reviewing this Knox County Sessions warrant, docket number 1394125, you were aware of the allegations that were made by Lana Spence, correct?
Yes.
And you're aware that at this point in time, she had alleged that Mr. Spence, one of your employees, had began to choke her to the point that she lost consciousness, correct?
Can I see the document? Yes, she said that the rescue began to choke her.
And you were also aware from reviewing this warrant dated April 4th, 2021, that there were allegations that there was photographic evidence of the incident, correct?
Let's see the document again.
Sure. I'll refer you to the second paragraph of Exhibit D.
Yes.
And you were also aware of warrant number 1395420, which is, I believe, exhibit number E, for violation of an order of protection, protective order conditions of release, correct?
Thank you. Yes, that's correct.
And after reviewing those two arrest warrants as the Knoxville Fire Department chief, you had a number of options that you could have taken as it relates to Mr. Spence's employment, correct?
That's correct.
And in this instance, you could have chosen to place him on administrative leave, correct?
Correct.
You could have chosen, it was within your discretion, to bring him back to the fire department in different circumstances, correct?
That's correct.
You could have terminated Mr. Spence, or let me rephrase that, you could have initiated proceedings to terminate Mr. Spence, correct?
That's correct.
And you were aware that the aggravated domestic violence charge, or were you aware, was a Class C felony under Tennessee law? It's not going to say it. I can show it to you. Were you aware it was a felony, Chief?
Yes.
And you were aware that it was a felony that, if convicted, could carry a significant period of confinement?
Yes.
And after reviewing the narrative on exhibits D and E, the narratives, it was your opinion and decision to return Mr. Spence to work at the Knoxville Fire Department, correct?
In a different capacity, not on the fire trucks.
Correct, but my question is, you decided to return Mr. Spence, reinstated his employment with the Knoxville Fire Department, correct?
Well, his employment was never taken away. He was on light duty. I mean, he was on admin leave with pay initially, and then we brought him back to work in one of our divisions.
And you decided not to keep him on admin leave with pay, correct?
That's correct.
You decided not to initiate termination proceedings of his employment, correct?
That's correct.
And with full knowledge of the felony charges and the narrative on the warrant, you felt it appropriate for Mr. Spence to return to work, correct?
Correct.
And in making that decision, was it something done with complete consideration of Mr. Spence's record as a senior firefighter?
No, I don't think I would say that. It was going on for a very long time. We actually thought this would have been resolved much sooner than that. So we brought him back into capacity where he would not be providing any EMS treatment to anyone. He wouldn't be dealing with any of our patients, and he would have very limited contact with others in the fire department.
Well, he was in the admin office, correct?
It was in the EMS office.
EMS. So, and you felt that was appropriate, correct?
At the time, yes.
And you were aware, were you not, that Mr. Spence had been employed by the Knoxville Fire Department for approximately 13 and a half years at the time, correct?
I don't remember the exact, but yeah, he'd been there for a long time.
And aside from the incident that we talked about with the harassment issue where you indicated Mr. Spence kind of hesitated on whether to accept responsibility in 2015, he had a basically blemish-free record with the Knoxville Fire Department, correct?
I don't know if I can say that. He didn't have any other disciplinary actions taken against him.
He never had any other disciplinary actions, correct? And in fact, he had received, and let's talk about his employment status specifically. In April of 2021, Mr. Spence was a senior firefighter, correct?
I believe that's correct.
Well, are you unaware of what his employment was at the time?
I was just having to think about what his rank was. So I do believe that he's a senior firefighter.
And you're aware that Mr. Spence had certain professional licensures, correct?
Yes.
And you're aware that he was an emergency medical tech.
That's correct.
You're aware that he had an advanced EMT license, correct?
Yes.
And you're aware that on one occasion he became or was recognized as an employee of the quarter, correct?
Yes.
And you're aware that there were numerous individuals that contacted the fire department and commended Mr. Spence on work that he had performed during the scope of his employment.
I'm not object to that. I believe he's got hearsay there. If he's got a document to show it, that's fine.
I would respectfully say I thought hearsay was not applicable to civil service hearings. But
Testimony
rules
of
change.
testimony of the attorneys is definitely
We have this
not
marked
permitted.
as the next exhibit, please.
DD?
We're going to change gears a little bit before I ask you about
Is
some of
this
the.
what you just gave them? I didn't get a copy of
I just gave, that's what I just had marked.
them. Okay,
Yeah.
I didn't know that was not.
Okay.
This is an email reportedly from Jonathan Beatty.
Let me show you this. Were you aware that after Mr. Spence's plea, that he was informed that he remained in good standing with the Board of Health regarding his licensure as an emergency medical technician?
Yes. Harry gave me this document.
So that is exhibit
DD.
DD. And in that exhibit, the Board of Health references that they were specifically aware of his plea to the misdemeanor offenses, correct?
Yeah, it states that, thank you for informing me of the incident and misdemeanors that are now on your record.
And in determining whether there was just cause to terminate Mr. Spence in November of 2023, did you take into consideration that the Board of Health had maintained his licensure after his plea?
Yes.
And what weight did you give that fact that after learning of the misdemeanor plea, that his licensure as an advanced EMT was still intact.
I don't know, I can say what weight I gave to it. I took all the information that I had and weighed them all.
And it's marked as EE. Let me show you a memorandum that purports to be from yourself, and it's been marked as EE, and ask if you can identify that document.
Yeah, this is where Harry was given a Distinguished Service Award in 2018.
And can you read to the record the criteria for the award that's set forth in the second sentence?
This award is given to members who render service of unusual intelligence, alertness, or skill, which results in the solution of a firefighter rescue, fire prevention, or administration problem, and outstanding service or contribution to the fire department or community which sets them clearly above and apart from their peers.
And I think it goes on to say, in addition, the recipient will be presented with a gold and red colored bar for his uniform.
That's correct.
And that memorandum is from you, correct?
Yes.
And those are your initials, correct?
Yes.
And what is the date of this Distinguished Service Award?
August 10, 2018.
And does that accurately reflect your opinion of Mr. Spence as a senior firefighter with the Knoxville Fire Department at that time in 2018?
Well, it reflects on what he did at that time. I don't have that right in front of me.
Well, it says it's given to people who are of unusual intelligence, alertness, or skill, which results in the resolution of a firefighter, rescue, fire prevention, or administrative problem, and outstanding service or contribution to the fire department or community, which sets them apart from their peers. So, would you agree with me that this memorandum recognized Mr. Spence for being an employee that was clearly above and apart from his peers, correct?
I would say that the actions taken on that day deserved an award.
And
I don't have that action right in front of me, so I don't recall what it is.
well, you had the 2015 write-up and you had all this other information, but you never considered in your just cause termination Exhibit EE?
Absolutely, I did. I reviewed his personnel file when I went through before I decided what to do. So yes, I took that into consideration.
Chief, what did you give him the award for then? If you reviewed it and you took time to consider.
I think this is one where he saved a life off duty. I don't recall for sure, but I believe that's what it was. I performed CPR on someone when off duty.
Would it have been an incident at Neyland Stadium that Mr. Spence responded to?
That sounds correct.
If someone had actually was clinically dead and Mr. Spence helped revive the individual?
I don't recall all those details, but yeah, he did. Best I can recall, there was someone who went into cardiac arrest and he performed CPR.
And if we could have this marked as FF. And I apologize for that. I don't know why I get tickled. I haven't used alphabetical letters on exhibits in eons.
So first for me.
FF. Let me show you what has been marked as the next exhibit and see if you can recognize this. Chief?
Yes, it's a note of appreciation given to the Quint 17B crew.
And I think it references senior firefighter Harry Spence.
That's correct.
And is that your name and initials?
Yes, it is.
And can you read your memorandum into the record, please?
Okay. It's a note of appreciation. Attached is a copy of an email I received from Miss Dottie Martin, who fell in her driveway on Tuesday, September 29, 2020. She writes that the three gentlemen who picked her up were courteous and professional and provided her with needed reassurance, which I'm sure she appreciated. I want to thank you for doing a great job representing the Knoxville Fire Department and to let you know that I appreciate your hard work and dedication to the department.
So,
Good work.
shortly after Mr. Spence received the award, he again received an accommodation or note of appreciation from you regarding his service to the Knoxville Fire Department, correct?
That's correct.
And what weight, if any, did you give that in determining whether there was just cause for termination of Mr. Spence's case?
So, like I said before, I considered all the information that I have. I can't say exactly what weight I gave to that.
Gigi? Chief Sharp, let me ask you to look at what's been marked as exhibit number GG and see if you can identify that.
Yeah, this is a note of appreciation provided to the Engine 17B along with Engine 17A crew for in responding to an email that I received.
And is Harry Spence specifically, one of the addressees?
Yes, he is.
And is that your name and your initials?
Yes.
And can you please read into the record your note of appreciation?
Attached is a copy of an email that I received from Mr. John Nix, along with my response to him regarding an accident he had Sunday, June 18, 2017, at his residence on Bridge Garden Road. Mr. Nix extends his gratitude to you for your knowledge and experience, but especially for your calming influence that helped him get through this experience. I want to thank you for doing a great job representing the Knoxville Fire Department, and to let you know that I appreciate your hard work and dedication to the department. Keep up the good work.
And were you sincere and accurate when you wrote this note of appreciation?
Yes.
And it was your opinion that Mr. Spence was doing a great job and that you appreciated his hard work and dedication?
Yes.
And with this next exhibit. Let me show you, Chief, what has been marked as Exhibit HH and see if you can identify that document.
Yes, this is a letter of appreciation provided to Engine 17B and Engine 17A, one person permit. In response to that, a letter that I had received.
And is Harry Spence one of the addressees on the memorandum or recipients?
Yes, he is.
And this memorandum was from whom?
From me.
And those are your initials?
Yes.
And can you please read the letter of appreciation into the record?
Attached is a copy of a letter from Mr. Hank Bertelkamp that was sent to me commending your actions during a medical emergency that he experienced at his office on December 27, 2016. He described the quick response and professionalism of the firefighters and his favorable outcome. I I want to thank you for doing a great job representing the Knoxville Fire Department and let you know that I appreciate your hard work and dedication to the department. Keep up the good work.
And is the opinions that you expressed in this letter of appreciation, were they true and accurate at the time?
Certainly.
So you would agree with me that Mr. Spence has received numerous accommodations from the public regarding his job performance, correct?
Yes.
And that you have recognized him on multiple occasions regarding the manner that he carried on his job responsibilities, correct?
Yes.
And in fact, he was the recipient of a Distinguished Service Award, correct?
Yes.
And it was within that context that when Mr. Spence picked up the felony ag domestic, you chose to let him to return to work, correct?
Can you say that again?
It was in that context of his employment history that you made the decision to allow him to return to work after you reviewed the warrant for his arrest for aggravated domestic assault.
I allowed him to return to work because at that time, those were, although they were very serious charges, they were just charges.
And again, you noted that they were, quote, very serious charges, correct?
Yes.
And in fact, I think there was at least 3 occasions where Mr. Spence's leave and status had been extended by yourself, correct?
No, that's correct.
And at some point in time, you were aware, and I think Ms. Dyer showed some text messages that Mr. Spence was arrested for 10 days for violating his bond conditions, correct?
Can you state that again?
He served approximately 10 days for violating the bond conditions.
That's correct. I think he told us 9 days.
And you've referenced the criminal court files and all this. Did you obtain those records where he denied doing anything wrong?
I'm not sure what that record is.
Did you obtain, when you see the text messages, did you attempt to verify whether that was his phone number or someone else's phone number?
No, at that time I did not.
And would you have had Mr. Spence's phone number on file, readily available?
Yes.
And are you aware that Mr. Spence adamantly denied that that was his, those were his text messages and that he had violated the bond conditions in his case?
Which one? The text messages?
Well, the text messages, were you aware that he denied that they were his?
Which text messages? I do know that at one point he denied that some text messages were his at the hearing.
And you're aware that he denied that he violated the violation of the order of protection, correct? Or bond conditions?
I do believe he said that at the hearing.
And are you aware that was subsequently dismissed, I believe?
I don't recall that.
Now, in determining or making a decision to discipline a member of the Knoxville Fire Department, what is the scope of your authority in terms of discipline?
That I can provide anything from a counseling form to termination.
And you would agree with me that there are basically three sources or three bases that gives you the power to discipline. One would be the county charter, correct?
Objection.
City charter, did I say county? I'm talking to Mr. Jacobs. I apologize. City charter. Second would be the administrative rules of the city of Knoxville, correct?
Yes.
Third would be the Knoxville Fire Department Manual of Policies and Guidelines, correct? And you would agree that if you make a decision for termination under Administrative Rule 11E, you have to determine whether there was just cause, correct?
Do you have a copy of the rule?
Here's a copy. If you need to read it.
Just think it'd be helpful for it to be in front of them.
And you would agree with me under 11E that there is a requirement for you to make a determination of just cause before there is a termination, correct?
Correct.
And in determining just cause, you would agree with me that it is important to consider a variety of factors regarding someone's employment with the fire department, correct?
Correct.
One of those factors that would be important to consider in determining just cause would be the length of their employment with the department, correct?
I don't know that I could say that.
So if someone committed a serious infraction a week after they were employed, that wouldn't have any different consideration than someone that had been with the fire department for 10 or 15 years?
You can certainly take into consideration, someone's record with the fire department.
Let's start with this. Just cause also includes someone's job performance and work history with the fire department, correct?
I don't know that I could say that.
Well, so are you telling me that in this case, you did not consider any of your letters of appreciation or the Distinguished Service Award as it related to your decision to discipline Mr. Spence first and second to recommend termination?
Objection. Asked and answered. You asked earlier if you considered him, and he said yes.
Well, now I'm asking specifically on the issue of just cause. Did you factor in the Distinguished Service Award and all the letters of appreciation that Mr. Spence received?
I factored in everything I read in his personnel file, which included those.
And would there be a record when you, how do you physically review his personnel file?
Get the folder and I go through it.
And do you have to check it out? Is it on your computer? How do we know when you reviewed it?
It doesn't have to be checked out. I just asked my assistant to provide me a copy of his personnel file.
So you considered this information in determining just cause under City of Knoxville Administrative Rule 11E, correct? And did you take the time to interview any coworkers or supervisors about Mr. Spence's job performance? Would you agree with me that that would be important to talk to his chain of command in factoring in just cause?
No, not necessarily.
Well, let's think about this. You knew he was charged with felony aggravated domestic assault, which carries 3 to 6 years in the Department of Corrections. And for whatever reason, and you were aware of the narrative where the individual said she was strangled and there was photographs, correct?
Correct.
And you had the choice to keep Mr. Spence away from City of Knoxville Fire Department property, correct?
Correct.
Admin leave. You had the choice to recommend termination, correct?
Correct.
Where you had the choice to bring him back to work. And it was your opinion at that time that notwithstanding those allegations, it was just cause, whatever you want to call it, to put him back to work around other employees, correct?
Can you state that again?
Based on your knowledge of what he was charged with, you felt it was appropriate to return him to work, correct?
Yes.
Now, between the time that you recall when you allowed Mr. Spence to return to work,
I don't recall that date.
let me, we'll get back to that in just a minute. But Mr. Spence goes back to work, and then in November of 2023, you recommend that he's terminated, correct?
That's correct.
And you would agree with me that between November 21st and the time that Mr. Spence was placed back to work, nothing had changed regarding his employment at the fire department. He hadn't picked up any infractions, no write-ups, etc., correct?
From what dates?
From the date he was placed back, allowed to return to work, and before your notice of termination.
That's correct.
And you would agree with me that you were of the opinion that it was appropriate for the fire department to have Mr. Spence work in the administrative offices of the EMTs, correct?
Correct.
And something changed at some point in time that caused you to recommend additional discipline, correct?
Yes.
And that something was what?
Well, it started with his pleading guilty to reckless endangerment and harassment.
Okay. Can you tell me specifically how you found out that Mr. Spence had entered a plea of guilty to 2 misdemeanor offenses?
I don't recall how I first found out.
And we have a copy of the guilty plea that Ms. Dyer asked you about. Were you or any of your employees present at the time Mr. Spence entered his plea of guilty?
No.
And after you found out he had entered a plea of guilty, what did you do, if anything, to find out what he had pled guilty to?
At some point I was provided with all of the court records, including both transcripts, the judgment from the court, the medical files. So I was provided with all of that.
And who were you provided that by?
It was probably my attorney.
So did you ask for it, or did it come to you unsolicited?
I don't recall that.
Well, you're the one that made the decision to terminate Mr. Spence on November 21st. Did you ask for any documents to review?
Oh, I certainly, if I did not, I certainly would have. But I was provided with them, so I reviewed them.
And you think it might have been your attorney?
I don't recall whether I asked for them or whether she just provided them to me.
Is your testimony today, or you have testified, that you determined just cause because you looked at everything in the criminal court file, correct?
Yes. Everything that I had.
And did you watch the body cam videos in their entirety?
Yes.
And when did you do so? And on what computer?
I don't remember the exact date, and I don't remember what computer. I watched them actually on multiple computers because to make sure I got the best sound.
Was anyone else other than your lawyer with you when you reviewed the body cam videos? Do you recall how long the body cam videos were?
I think they're about 40, 45 minutes each.
Did you take any notes of the videos?
Yes, just jotted down like times, what was said.
And where would those notes be maintained typically?
I'm gonna object. Attorney-client privilege.
Well, if it was a communication to your attorney, I don't want you to tell me, but if it was just notes that you kept as chief of the fire department, we've requested those memorandums and that information. Did you make notes independent than a communication to your counsel regarding your review of those videos?
No, I don't think so.
Well,
I think I had, if I took notes, it would have been for her, for me to discuss with her.
I object.
Well, do you recall your letter that we have talked about of November 21st, 2023, termination letter? What day did you decide to terminate Mr. Spence? This letter is dated November 21st. When did you make that determination, Chief Shelter?
I don't remember the exact date.
Well, this transcript you say that you read is a transcript of guilty plea August 31st, 2023. So between August 31st and November 21st, when did you review the transcript of guilty plea?
I'm gonna object to characterization. There's two transcripts for the guilty plea. One in August and one in September, so I'm gonna object to the question.
Both. When did you review both? They're in the record.
Reviewed it multiple times.
Well,
I don't recall the date.
do you have any notes or memorandum regarding your review of the transcripts?
I know.
Where would those transcripts be that you reviewed?
The original transcripts?
No,
Right.
the ones that you reviewed.
I don't know. I mean,
What would that be in Mr. Spence's file if I requested a copy today since you reviewed that information and terminated it?
they would be in the file that I have of the information I reviewed, yes.
Where is the file of information you reviewed?
I assume it's back in my office.
Your Honor, at this point, we would ask that we be provided a copy of that file. I think it,
Object, we provided him a copy of everything when he was terminated. Mr. Isaacs filed a public records request for his personal file as well as the documents regarding the incident that were provided then. That was in early November. He was also provided copies of the records that were reviewed when he was terminated, which was after he provided information November 9th. I think the letter's November 21st. He's been provided the copies multiple times.
if it's something I've been provided, obviously I'm not asking to receive it again. But if he has a file that is separate, that's responsive to my request, I would ask for a copy of that before I continue this examination.
I'm gonna object, he was provided that in discovery, he was provided that, everything that's not privileged, you've been provided, that was from that file.
The question then is, did you provide him a copy of the file of the materials that you reviewed?
Yes, I did.
Okay.
Tell us what's in that file.
So there are,
I'm gonna object first to anything that might be privileged, but up to him.
transcripts from the hearings, our hearings, the pre-disciplinary hearings. The court records, which I've already gone over from August and September. Pre-disciplinary notices.
What else? Do you recall?
The copies of the original charges. The document that you provided after our October pre-disciplinary hearing.
And so we know for you to have reviewed all those materials, it would have been after, it would have to be after the September transcript, the plea hearing, correct?
That's correct.
And before November 21st.
Correct.
And you recall when you reviewed all that information in that window of time?
Not exactly. I reviewed it multiple times, but then
Well-
after,
Well, we talked about this waiver of plea, that's dated September 20th. So we know that the court reporter couldn't have prepared the transcript in real time. So do you recall when you got the transcript that you were referring to? Because you say you relied on it in determining just cause for your November 21st letter. So it typically takes a few days or a few weeks for a transcript to be prepared. When did you get the transcript that you considered?
I don't recall.
Could it be possible that you didn't review it?
I did review it multiple times.
Well, you only had it less than a month, 4 week, 3.5 week period, because the plea was September 20th, letter of termination was November 21st, correct?
I don't have those dates memorized.
Well, so let me ask you, and I put the termination letter is already in. Madam Court Reporter, do you recall what letter this is?
This is letter termination that I completed and you know.
Why?
Why? Thank you, Mr. Roach. So, Exhibit Y, did you write this letter? That's your signature, correct?
Yes, that's my signature.
And this was given to Mr. Spence via hand delivery, correct?
That is correct.
And did you write that letter? Or did someone write that for you?
With help from my attorney.
Well, I don't want to know what you, I'm not asking what you, communications you've had with your attorney, but is this letter, Exhibit Y, was it written by your attorney or was it written by yourself?
Asked and answered.
I apologize because I didn't hear the answer. Did you write this? Or did someone else write this?
It was got from my attorney.
Well, how much, I mean, is it 90% yours? Is it 10% yours? I mean, you signed it as fire chief, and you carbon copied your attorney. So how much of this did you write?
I don't know, I can say exactly what percent I wrote, but I absolutely agree with it. And
Well, you're the fire chief, it's your decision. I mean,
absolutely.
surely you would agree with your own decision, I would imagine. So, who chose the bases for Mr. Spence's termination that is cited regarding the Knoxville Fire Department manual policy guidelines and administrative rules? You referenced 3.22 and 3.26 of the Knoxville Fire Department manual policies and guidelines. Was that your decision to include those two policies and guidelines, or was that someone else's?
That's my decision.
Let's look at, you have that letter in front of you,
Which one are you talking about?
November 21st termination letter. If you could turn to the page where it cites the policies that you relied upon. And can you read 3.2.2 for the record?
Members of the department, whether on or off duty, shall be governed by the ordinary and reasonable rules of good conduct and behavior, and shall not commit any negligent, malicious, or criminal act which may bring reproach or discredit upon the department or city of Knoxville.
And is this this policy or guideline, is there discretion in terms of your opinion as to whether an act that is negligent, malicious, or criminal may bring reproach or discredit to the department or city of Knoxville? Well, it says, and you relied on it, that members of the department, whether on or off duty, shall be governed by the ordinary and reasonable rules of good conduct and behavior, and shall not commit any negligent, malicious, or criminal act. And then it says, which may bring reproach or discredit upon the department or city of Knoxville. So is it your decision to determine whether an act, whether it be negligent, malicious, or criminal, brings reproach or discredit on the department or city of Knoxville?
Yes.
And it was your opinion that when Mr. Spence was charged with a felony offense, that it was appropriate for him to maintain his employment with the fire department and return to work, correct?
That was just a charge. There's a huge difference between a charge and a plea.
And there's a huge difference between a felony and a misdemeanor. Would you agree?
Yes.
And is it, in determining just cause for determination, you've mentioned the offense of misdemeanor reckless endangerment. Are you aware that under Tennessee law there's felony reckless endangerment and misdemeanor reckless endangerment?
I'm not exactly familiar with that.
And you've mentioned the significance of reckless endangerment on more than one occasion during this hearing. What is your understanding of what the offense of reckless endangerment is as it applies to Mr. Spence in this case, since you reviewed the criminal court file in its entirety?
So I probably won't get it exactly. I haven't reviewed what the definition is. And it's.
I started to interrupt and I stopped myself. So I
So I have
please
reviewed.
continue.
I have reviewed the definition.
And can you tell us what reckless endangerment is based on your understanding?
I'll try to put it in my own words that when someone recklessly either causes or may cause harm to another individual so that it puts them in imminent danger of death or bodily harm, something to that effect.
Would it surprise you that those are the elements for felony reckless endangerment that Mr. Spence did not plead guilty to? Let's go to policy manual guideline 3.2.6. First of all, how much weight do you give these policies and guidelines when you cite them as a basis for determination? I mean, obviously you thought that this was material and fit the factual scenario of Mr. Spence, correct? 3.2.6.
Yes.
Would you not agree with me that this 3.2.6, you could fire anybody at any time if they committed a traffic violation, if they committed a burn ordinance? I mean, it says all laws and ordinances of the United States.
So
I guess my question is, would you agree with me that 3.2.6 could mean anything and everything?
No, I wouldn't. It does state that you will comply with all the laws, but not all of them would rise to the level of discipline or termination.
Of all the laws and ordinances of the United States, is that a policy of the fire department? And you cited it in support of termination.
Objection, is there a question?
Well, okay. Now, the second part that you relied on, can you tell me what this means? Because to me it seems nonsensical. At no time shall a member be ordered to violate the rules and regulations of the city of Knoxville or other law.
It just says what it says.
Well, I don't know.
A member can't be ordered to violate any rules or any other law.
Why was that significant in this case or any other case?
Because it was just part of that 3.2.6. It's in the same rule.
But wouldn't you agree with me that rule doesn't really mean it gives us any guidance at all? Because it says, shall comply with all laws, ordinances of the United States, state of Tennessee, and city of Knoxville. I mean, as fire chief, do you think it's reasonable that an employee should know all the laws and ordinances of the United States, state of Tennessee, and city of Knoxville? Or is that just something we use to rubber stamp terminations?
Absolutely not.
Then what does that mean?
It means that you would attempt to comply with all laws and ordinances of those entities.
And you can be terminated if you violate any law or ordinance.
Now, you still have to have just cause.
Okay. Well, but you would agree that was the framework in terms of your analysis of what just cause was. And you thought it important enough to cite a provision that says that you can't order people to break the law. I mean, have you ever reviewed these, Chief?
Yes.
Well, why is that still in there? 3.2.6, and why is it important for Mr. Spence's case and just cause?
It states that you must comply with all laws of the United States, state of Tennessee, and city of Knoxville, and he admitted to breaking one of those laws, two of those laws.
Well, you thought he had committed felony reckless endangerment based on your understanding of the elements. But my thing is, why does the fire department think it's important enough to put in writing that you can't order people to violate the law? If you take these rules seriously, what on earth is that in there for?
I do take these rules very seriously, and when I'm referring to this rule, it is that the members of the department will comply with all laws and ordinances. That's the rule. That's the part of the rule that I'm referring to.
Let's go to 1103, which is the City of Knoxville Administrative Rules. And that's also cited in your November 21st letter, correct?
Yes.
And let's be clear that this is the criteria under which you determined there was, quote, just cause. These 5, not statutory, but these 3 administrative requirements, these 5.
Yes.
Okay. Violation, okay, 1103E, violation of rules, regulations, and procedures of a department. So, what does E refer to specifically in Mr. Spence's case? What rule, regulation, and procedures of a department did Mr. Spence violate?
The 3.2.2 and 3.2.6.
So that's basically redundant. E encompasses 3.22 and 3.26, correct?
That's correct.
Any legal offense, depending on fine or sentence. So, would you agree with me that likewise is fairly overbroad? What does the term any legal offense mean?
I think it's offense. It's not like offense in basketball, it's an offense.
Well, I want to know what a legal offense means in your understanding, since you listed it as a basis in determining there was just cause to terminate Mr. Spence.
It means that if there is a legal offense, a breaking of a law, depending on the fine or the sentence, it can be a reason for discipline.
And then in any other just and reasonable cause. So that could just mean, and reasonable, does that mean you're the sole arbiter of what is reasonable cause or not?
I am the one who has to make that decision.
And if you had the wrong legal standard, for example, for reckless endangerment, do you think that would be something important to consider?
I object to the characterization.
Well, you said that you thought reckless endangerment was defined as, for the elements, serious risk of death or serious bodily injury, and that's a felony. This is a Class A misdemeanor. So you would agree, if you were under that fundamental misunderstanding in determining just cause, your decision may have been flawed as you weigh through these requirements in terms of what is just and reasonable.
No, I would not say that.
Well, but we know the conduct, allegations themselves, in your opinion, were not severe enough to keep Mr. Spence away from City of Knoxville Fire Department property, correct?
Objection. That's not what's been testified to.
You put him back to work after you read the warrants, correct?
Yes.
You put him back to work after you knew that he did 10 days for allegedly violating his order of release, correct?
Yes.
And after the serious felony got reduced to a misdemeanor, under these 5 criteria, you felt it was just cause to impose the most serious punishment you could have, termination, correct?
Yes, absolutely.
And isn't it true that in reality you did not consider his accommodations and distinguished service awards?
No, that is not true.
Well, What number is this? Medical report.
Your question is as to your letter?
My letter.
I think it's,
Yes,
X.
X.
X marks the spot. Or one know is.
Or from, I just got, that was some good hearing officer humor. Let me show you Exhibit X. Can you identify that document? You identified it before, but we have it in front of you again. You recognize that as the supplemental letter and information that was provided on behalf of Mr. Spence?
Yes.
Did you review that letter?
Absolutely.
Did you consider that information that we provided in determining just cause?
Yes.
In determining that there was just cause to terminate Mr. Spence pursuant to Administrative Policy Guidelines 322 and 326 and Rule 1103 E, G, and N, was it the fact that Mr. Spence pled guilty to a misdemeanor criminal offense, or was it the factual basis of the criminal offense that you felt supported just cause?
It was all of the information I had. He pled guilty to 2 offenses, reviewing the medical records, reviewing the body cams, reviewing what he told me in the hearings. It was all of that information that there was just cause to terminate.
And I am about finished, and I have misplaced, sorry, maybe you can help me, the email from, oh, here it is, it's right in front of me. We talked about this email before from, am I pronouncing her name correctly? Is it Plant? Plant.
She was by JP.
And JP wrote you an email. Have you seen that email before?
Yes.
And you would agree with me, it's a very detailed email, correct?
Yes.
Like she references transcripts of the plea, correct?
I would have to look at it.
I object once again to the relevance this wasn't considered.
Well, first let me ask you this. Isn't it true that Miss Plant did not work with Harry Spence at any time in the fire department?
I don't know if that's true or not.
All right, and it's your, or is it your testimony that you never relied on any of the information that Ms. Plant provided to you during this email.
That's correct.
Did you or anyone in your office provide Ms. Plant with any of the information from the criminal court case involving Mr. Spence?
Not that I'm aware of.
I mean, did it concern you when Ms. Plant accused Mr. Spence of being involved in arsons? And there's absolutely no evidence whatsoever in his personnel file or anywhere to support that. Did that give you any cause for concern when you read this email?
Like I said before, I didn't take this email into consideration in my decision at all. I simply forwarded it to the law department and then forwarded it to civil service to handle.
If I can have just a minute.
Sure.
Mr. Henry, examining officer, we have no further questions of this witness.
All right. We are at a,
I have a very short redirect that I'd love to do so we could be done with this witness. Is that possible?
it's possible.
It's up to you. Your thoughts.
Is it probable?
Proceed.
Very short. Mr. Isaacs asked you about when you initiated disciplinary action against him and talked about the November letter. I'm going to show you what, I'm not sure which has been marked, the April 20th, 2021 pre-disciplinary letter. Can you read the last sentence of the the second paragraph out loud?
This incident, if true, may be a violation of the following rules of the Knoxville Fire Department Manual, Policies, and Guidelines, and could result in disciplinary action being taken against you up to and including termination.
Would you consider this initiation of termination action with regard to these two offenses?
I'm sorry.
Would you consider this the initiation of this pre-disciplinary action with regard to these two offenses?
Yes, it was.
With regard to the fact that the state had allowed him to keep his license, do you know what Mr. Spence told the state with regard to the charges?
So I don't have that information.
Is the state responsible for the employees that work for you and work with Mr. Spence?
No, I'm responsible.
Is the state responsible for patients that Mr. Spence treats?
No, they're not.
Do you have 11.03 in front of you? Mr. Isaacs took considerable amount of time talking about incidents in his personnel file. I direct your attention to 11.03. E, would you read the last sentence of that paragraph, 11.03E? Would you read it out loud? 11.02E.
Just cause may also be based upon a single event or condition without previous disciplinary actions if the event or condition in question justifies immediate termination.
So can a single incident, if it's serious enough, justify termination?
Absolutely.
And a lot of firefighters have awards and commendations in their
Jack
personnel file.
Leading.
Do a lot of firefighters have awards and commendations on their
Yes,
personal?
they do.
But if there's one incident that's serious enough, do you believe this one incident was serious enough?
Objection, leading, ask and answer.
Do you believe that this incident was serious enough to justify termination in and of
Objection,
itself?
ask and answer.
I don't know whether she got it out and asked, but let her to finish her question and to respond.
Do you believe that this one incident, in fact, two incidents, because it was two misdemeanors, justified termination in this case?
Absolutely.
Mr. Isaacs also asked you some questions with regard to why did you allow him to come back to work? What was your understanding of Mr. Spence's plea when he first was charged?
That he was denying those charges.
Did he plead that he was innocent to the charges?
Yes, he did.
Thank you.
Some of the cases that we all are familiar with, not criminal cases, but civil cases involving civil service. Talk about substantial shortcomings of an employee as justifying termination or some disciplinary action. Did you or do you regard Mr. Spence's two misdemeanor convictions to be substantial shortcomings?
Yes, sir, I do.
Why?
Because as members of the fire department, the people that we serve have to trust us. They have to trust us to take care of them. They have to trust us to just trust that we are going to do what we're supposed to do. And these actions that he took on that night showed that he pled guilty to, he caused physical harm to his wife, and therefore I don't feel like I can trust him to never do that again. He pled guilty to that. He also he pled guilty to harassment. He had one other incident where he admitted to harassing a female firefighter. So because of those, I do believe there was just cause. And I hope I answered your question.
All right. Anything further with this witness?
Not on behalf of Mr. Spence.
Not on behalf of the city.
I think most everybody was on call, due 15 minutes. It might be the best if we take the lunch break. And we're back to, it's not quite an hour, but it's, well, it's actually, it's a little over two. It's a little over two. You got a walking clock to look at. I'm looking at my watch and I can't tell time. So we will take a break until 2 and the city will continue with their witnesses and Mr. Isaacs can call what witnesses he wishes to call.
Very well.
You ready for your next witness?
The city has no other witnesses. We would like for the court to, or the hearing officer to take judicial notice of the statute of reckless endangerment. TCA 39, version 103. You may know what it is. We have no other witnesses, Your Honor.
All righty.
If I could have 3 minutes, for my client,
Do you
we
want
may,
Amy to call any of the witnesses and have them head
if you'll just give me 3 minutes,
3 minutes.
we may shorten things significantly. At this point in time, Mr. Spence, the appellant rests.
Okay.
So she's gonna go ahead and release the rest of the witnesses.
Well, I don't like their emails. We just make them stay here till 4:30. I'm being very facetious.
Go ahead.
No, please do.
But she's still waiting.
All right then. This hearing is now concluded. I will consider what I've seen and heard this morning and into the early afternoon and get you all a decision. I think I have 10 days, but I don't think it would take 10 days to do it. I usually don't take 10 days to do that, Teresa. So anyway, I'll get a decision out as quickly as I can, and if there's nothing further, we stand adjourned.
Thank you, Mr. Hearing Officer.